dream I know deep up my feelings for you.
Hello viewers, welcome back to this channel. Thank you all so much for joining us. The headlines: more reason why Nnamdi can never be tried in any Nigeria courts. Before I carry on with this news, welcome to Reality Latest Gist, your home of news and politics. Thank you all so much for joining us on today's news. If this is your first time of watching, please do us a favor to like and subscribe, and also turn notification bell to get notified when next we drop our video, because I'm sure you don't want to miss out the trending and latest news happening on social media. You can send in your comments and keep the conversation lively in our comment section. To all our amazing subscribers, thank you all so much for joining us. To all our viewers, feel relaxed, enjoy and stay connected. Nnamdi infamous extraordinary rendition. Nnamdi was on 29th of June 2021 secretly arraigned and without benefit of his counsel of record before the Federal High Court, Abuja, on the 4th count pre-rendition charges standing against him as of that date. The charges were namely treasonable felony, conspiracy to commit treasonable felony, illegal importation of radio equipment, and defamation of President Muhammadu Buhari. In extradition practice, these charges are known as pre-extradition charges or pre-redemption charges, such as in this particular case. Subsequently, in a slew of amendments of charges, the then Attorney General of Nigeria, Abubakar Malami, withdrew all but one of the said 4-count charges and replaced them with an entirely new set of 14 count charges that all bordered on terrorism and membership in proscribed organization. In the course of time, the Federal High Court, pursuant to application made, reduced the charges to 7 counts that were later quashed by the Court of Appeal, leading to the celebrated judgment discharging Nnamdi and barring of his trial in Nigeria. Without prejudice to any live judicial proceeding currently pending and concerning Nnamdi, the public has right to be informed of whether, after the redemption, it is legal for the Attorney General to abandon the pre-redemption charges and array a whole new regime of charges against Nnamdi post-redemption. The simple answer is that it is legal, because under the universal recognized doctrine known as the doctrine of specialty, which pertains to extraditions, a fugitive transferred from another country is subject to persecution only for those offences for which he or she was transferred. But where his transfer failed was that the master of the law or constituted a redemption, he is not to be subjected to any trial or detention, but promptly returned to where he was brought. This is common law, and Nigeria recognizes it and enacts at Section 15 of Nigeria's Extradition Act. In accordance with the law of any country within the Commonwealth, or in pursuance of an extradition agreement between Nigeria and other country, whether within the Commonwealth or not, any person accused of or unlawfully at large after conviction of an offence committed within the jurisdiction of Nigeria is surrendered to Nigeria by the country in question. Then, so long as he has not had a reasonable opportunity of returning to that country, that person shall not be detained, whether under this act or otherwise, tried or otherwise dealt with in Nigeria for or in respect of an offence committed by him before his surrender to Nigeria, other than a the offence for which he was surrendered, or any lesser offence which may be proved by the fact on which his surrender was granted, or b any other offences being one corresponding to an offence described in Section 20 of this Act, of the same nature as the offence for which he was surrendered, provided that a person falling within this section shall not be detained or tried for an offence by virtue of paragraph B of this section without the prior consent of the countries surrendering him. To be sure, the foregoing provisions were, as regards Nnamdi, breached in all these material particulars. First, as of 19 June 2021, when Nnamdi was abducted in Kenya, he was facing 4-count charge, none of which include or bordered on terrorism or proscribed organization. But today, the charges have been expanded to 14 new counts, all of which virtually bordered on terrorism. Unarguably, this is a clear violation of the doctrine of specialty, especially in view of the provision that a person falling within this section that is Section 15 of Nigeria Extradition Act, shall not be detained or tried for any new offense without the prior consent of the country surrendering him. This is also a double whammy because bringing up these new charges assume he is consequent upon the rendition triable for the pre-existing charges, which is wrong. In this particular case, the surrendering country is Kenya, and there is no evidence that her consent was obtained before these new 14-count charges were brought. To be sure, this Section 15 of Nigeria Extradition Act is ironclad, as it went further to absolutely bar detention and trial of such person under any other law, like the Administration of Criminal Justice Act or Terrorism Prevention Act, which the prosecution has sought to use in Nnamdi Kanu cases. To be clear, this is evident from the opening provision of Section 109 of Administration of Criminal Justice Act, which made the commencement of criminal proceeding subject to the provision of any other law. In this case, that other law is the said section of 15 of the Extradition Act, because Nnamdi Kanu was brought from another country, and by the rules of conflict of laws, the Kenya Extradition Act also applies in the same tenor. And as the Court of Appeal heard this barrier to detention and trial of Nnamdi Kanu shall upon his release persist against any rearrests consequent upon any new charges. In other words, Nnamdi Kanu must first be returned to Kenya as a starting point of any hope of ultimately prosecuting him in Nigeria for any pre-redemption or post-redemption offenses. There is no other way. Nigeria also strictly requires the same doctrine of specialty to be respected when it comes to fugitive extradited from Nigeria to other countries. Contrasted to fugitive surrendered to Nigeria, Section 3(7) of Nigeria Extradition Act stated that a fugitive criminal shall not be surrendered to any country unless the Attorney General is satisfied that provision is made by the law of that country, or that special arrangement has been made such that so long as the fugitive has not had a reasonable opportunity of returning to Nigeria, he will not be detained or tried in that country for any offense committed before he surrendered, other than any extradition offenses which may be proved by the fact on which his surrender is granted. The case of Abakari best illustrates the provision of this law, and that is precisely why it appeared to many that Nigeria was blocking Abakari extradition to America, or even the case of Sunday Igboho, whose extradition was spiritedly resisted by Benin Republic. So you can easily guess what the outcome would have been had Nigeria legally applied to extradite Nnamdi Kanu from Kenya. It is such outcome Nigeria avoided by resorting to rendition, which by hindsight cannot save the day, simply because it cut Nnamdi Kanu off from his constitutional to fair hearing, which applies in both Kenya and Nigeria. So guys, let me know your thoughts. Your contributions, your opinions are in the comment section. We'd love to hear from you. Once again, thank you all so much for staying tuned with us. We really do appreciate. On this note, we have come to the end of today's segment. Like, comment, awareness. Stay safe, guys. Bye.